There are growing frustrations over the slow pace of prosecutions on the high-profile state capture corruption cases, and with the National Prosecuting Authority admitting to capacity constraints, some believe that deferred prosecution agreements are the solution. But are they really? The first state capture trial involving the Gupta-linked Simelane investments, that's the case we commonly referred to as Simelane investments, and that was thrown out of courts. If you'll recall, this was due to a lack of evidence. But to help us unpack all of this is the former National Director of Public Prosecutions, Advocate Menzi Simelane. Advocate Simelane, thank you very much for your time. I want to kick off this conversation with the NPA in December of last year announcing that over 2.5 billion rand in punitive reparations to South Africa would be paid by ABB. This was the company that was involved in the construction of Kusile power plant. I'd like for you to take us into the processes, as you would perhaps know better than we do, why it is that the prosecuting authority would normally enter into such agreements, and what do they mean, by the way, for those who may have done wrong within these companies? Does that mean that they no longer are prosecuted?
Well, thank you, Koli. Good evening to you, and good evening to your viewership. Well, I think the most important thing is to always reflect and understand why we have something called a prosecuting authority. Any country does have it, and it's important to reflect on why it's there in the first place, right? And it is to conduct prosecutions with the best evidence that it has following investigations. And it is the outcome of investigations that determine how to proceed, whether there will be a decision to prosecute that can be taken, or whether or not there can't be a decision to prosecute, and in which case the matter dies until further notice. Where the outcome of an investigation gives evidence of the commission of a crime, the prosecution decision then gets taken to prosecute, and what gets assessed is what likely outcomes can be achieved with the evidence that is there. And that is where you find that negotiations then take place with a view to identifying priorities in the matter. Some get identified for prosecution, others get identified for witness availability. The idea there is to use some people who ordinarily would be prosecuted to provide evidence and be witnesses to secure the conviction of those who are identified for prosecution. And the difference between treating them differently is that you go for those that have committed the most serious crime amongst others, or because of their standing in society, and you want to make an example using them. So in this case, it's difficult to understand why the prosecuting authority would have chosen the route that it has chosen. The reading that one can make out of it is that, firstly, it's either it is not confident of its own case based on the outcome of its investigations, which is most likely that there's been investigations, they are not yet completed, and it's not clear how to proceed with what information the police have and the prosecuting authority has. I doubt it's the prosecuting authority that has a problem. It's more the police, because the ID is new and it doesn't have capacity. So the NPA, because it's being put under undue pressure to deliver a result, it is then using this mechanism to assist get a result that will get pressure off its back. And that's, in my view, is unfair to do for the prosecuting authority. But the reason why they would go this way is because the police are likely not to have completed the investigations, and a decision that is clear can't be taken at this particular point in time. But the people that are identified as having committed crimes, they themselves, because they are corporate, they don't need to be looking behind their backs and worrying about what's going to happen going forward. What they want to do is carry on doing business and bidding for business in many other countries around the world. So they can't afford to have this noise in South Africa about them being potentially prosecuted down the line.
Yeah.
So what they choose to do, as in any conflict, they choose to then have a settlement agreement. That's what in other cases, civil cases, it would be called. That let's rather have this matter settled so that we can go away. What do you need from us to make the case go away? And yes, we did benefit from the activities that are described. We think we benefited to this amount. If that is what you want, we will give you your money back without admitting that we committed any crime, because you still have to prove that. That's your obligation. That is what has been arranged here. And what they do as corporates, why they choose that option, as I've indicated, is to go ahead and do business. They'll recover that money in other deals. And if they don't have this kind of arrangement in place, other jurisdictions where they need to bid for business are going to say to them, sorry, we can't consider you until you are cleared in that particular case over there. So this is really a pragmatic way to make the case go away for the corporates and for the NPA to get a result in the meantime around that. Well, now, what a deferred prosecuting agreement is that all that happens is a couple of years down the line, I think in this case, I don't know what's agreed upon, it may be 3 years or 4 years, whatever the case may be, is that the NPA will revisit this agreement and then check the behavior of the companies concerned if they've remained clean. And if they've remained clean, which is basically a suspended sentence kind of thing, then the prosecution goes away for good. So for now, all it means is that they've been given a guarantee that for a certain period of time, they will not be prosecuted, provided they behave like good citizens or good commercial citizens. Then in future, if they have not committed a crime in this jurisdiction at least, then we won't prosecute them for good. They get excused from prosecution.
Yeah.
And for us, that's not our business. And the merits of this deferred prosecution agreement for our jurisdiction remains questionable.
Well, I would like to get your thoughts then, Advocate Simelane, on this specific case of ABB. And I'm picking on it purposefully because there are reports this Sunday from the Sowetan, the Sunday World rather, and they are reporting that the former CEO of Eskom, Matela Koko, is dragging the NPA to court in an effort to nullify this very agreement that you've explained so eloquently, because to him, he says that this is something that should not have been done. Firstly, what would his prospects be should the court choose to entertain his case?
Well, from what I've read about this agreement since last year, and what I know about deferred prosecution agreements and plea and sentence agreements generally, is that he has very high prospects of success as far as I'm concerned. And I think whatever and whoever is putting pressure on the NPA is doing the NPA a disservice, because it doesn't deserve this, right? This case can be dealt with and prosecuted properly in the normal course. You don't have to speed it up as if everything falls on it. It's actually not true, and it's not the right way of doing it. So he will succeed for the following reasons. In our jurisdiction, we have a way of resolving criminal matters, which is called a plea and sentence agreement, what are generally called plea bargains, right? So for you to get to the stage where you plea bargain with anybody, you must have a case that you believe you can prove, which if you put to the other side, they see that you may just prove your case, and they don't want to take a risk of defending and going to court and getting a conviction for the most serious part of that crime or crimes that you're charging them with. So what they do, they then say to you, we will plead to lesser crimes, but also agree to give us a lesser sentence. Then you win and we win while taking responsibility for what we have done. So in a plea and sentence agreement, there is a plea of guilty that an accused enters into. Yeah. It may be for a less crime, it doesn't really matter, but there is a plea of guilty, and there is therefore an outcome. What is important there, which is not in the deferred prosecution agreements, is that the plea and sentence agreement must be submitted to court. It must be placed before a presiding officer, a judicial officer, a magistrate or a judge, depending on where it is, and it must be considered. It must still be presented for approval. The fact that the NPA has been part of it and has agreed to it does not mean that the courts will accept it. It must still be presented, and the NPA then takes the burden of persuading the relevant judicial officer that this is in the interest of justice. This is the best thing under the circumstances. It's in the interest of justice, and it serves the purpose for which our laws are designed and intended to serve. Then the judicial officer will consider it and actually may disagree and say, actually, I don't think so. Satisfy me on a couple of things, as the case may be, right?
Yeah.
So in this case, assuming it was a plea and sentence agreement, I'm imagining that an objective judicial officer would look at this thing, understand what was happening. In this case, it's in the context of what is termed as state capture, which is not a crime, but it's a serious occurrence. And the judge will say, but if somebody was going to benefit or had benefited, in this case, it's ex post facto what we're talking about, right? So this party, ABB, had benefited, in other words, had made money in the amount or to the amount of about 2 billion rands. That's the money they'd taken and gotten away with. Why should they not be prosecuted? And the relevant people there prosecuted and convicted. Why are you letting them get away with it? Just because they want to return the money. Why is that making a difference? Because the money was identified to be with them. It was in their bank accounts. That money can be repatriated at any point in time. You prosecute them. It's not like the money could not be uncovered. It is known who got paid and how much they got paid. So why should they not be prosecuted? What is the actual reason that they get away with it?
Final question.
So the NPA will then have to tell the court that, well, in fact, they're helping us because they're giving us other information which we don't have, which information we will use to prosecute other people. Then the issue of selection, who you prosecute and who you do not prosecute, which we've always had a grapple with in this country in the past couple of years anyway, then will come into the fore in that you choose to let go from prosecution of a multinational simply because it gives you what you say you didn't have in the form of internal people within the entity concerned and maybe others we don't know. And those are the people who collaborated. And the NPA would say, yes, we are making that choice because we think we should make example of officials or whatever the case may be. So that is the choice. Well, so Machila Koko, if he's aggrieved by this, he's entitled to say, why pick on me? Why don't you use me and plea bargain with me instead? And I deliver the other people, if there are people to deliver for that matter. It depends what everybody has to say on the matter.
I want to end off on that very theme that you have now prompted, that the NPA may want to use officials as an example, because that is precisely what Matela Koko appears to be arguing, at least if I look at it from the view of this article, because he says the NPA seems to be obsessed with me, and yet they are willing to let go of this multinational. But here's a kicker. There's a new CEO that Eskom is anticipating should be starting on the 1st of March. His name is Dan Marokane. In this article, he is mentioned as having been thrown under the bus by Matela Koko, because Koko says, according to this article, he was ABB's inside man. Now, I would like to ask of you this question. If you were advising Dan Marokane right now, would you advise him to have a lawyer that would possibly watch this case very closely in court? In essence, should he be a worried man?
Well, firstly, he's not going to get free advice from me. The point is that at the end of the day, any person that is involved in activities which are under law enforcement investigation, therefore has an interest in the matter, is always best advised to make a decision whether they cooperate with and reveal what they know if they think it's relevant, or basically wait and see until such time that they are prompted to go forward. But all in all of this is really irrelevant. What matters is where the police are at with their investigations and what they have uncovered, because the police have a big latitude to speak to all of them and get statements from all of them and follow that evidence. The issue here that we all should be concerned about is, why are you rushing to get an outcome that is not beneficial for our country, as it were? Because what you are doing is you are saying to all the, and by the way, ABB is not the only one. There have been many others who have reached settlement with the NPA. KPMG is one of them. all collaborators in crimes that are of a corruption nature, allegedly fraud nature, and so forth, who simply decide, we'll give you back your money and leave us alone. Why is that an acceptable manner of dealing with criminality in this particular country? It wasn't before, but why is it so now? And is that a good thing for us as a country to be known for going forward? That you go to South Africa, do what you want, commit all the crimes you want, and then they'll let you get away with it because you'll simply, if you get caught, give them back their money and off you go. You know, that's a problem. The United States advantage, by the way, because we like being copycats, is that at least when that jurisdiction settles in this manner with its corporates, they punish corporates by taking a huge chunk of their money from their profits. So in terms of their laws, the DOJ has managed to extract as much deserved fines as they can possibly and justifiably get from the corporates involved. So they walk away with something. We walk away with nothing other than basically kudos on our back, which I'm not sure helps with fighting crime. So these issues must continue to be discussed, but we need to do whatever we can to assist the police to be able to produce that which it can produce for the prosecution to take forward and just stop giving excuses.
Advocate Menzi Simelane talking very passionately there about the deferred prosecutions. Thank you very much for your time and indeed insight. Just as a note, we did approach the NPA for comment. They told us they can't be available at this time, and we did approach Eskom as well. Well, they also couldn't be available. I'd like to put out an invite now, given that we have mentioned his name on this show. Mr. Den Marokane, if you feel that you would like to come through and talk to us about this particular case, you're welcome to, sir. This is an open platform.